Welcome to the polls live from our studios in Kokomleme. Coming up, Supreme Court expected to deliver its verdict in the NDC judicial review application. Will be live in court for the updates. Also coming up, fresh dispute to another constituency results in the Greater Accra region as a resident of Trovo files petition at an Accra High Court challenging the parliamentary results of the December election. And Joy FM Family Party in the Park leaves lasting impression on hundreds of patrons who experienced unforgettable moments of music, fun and bonding with loved ones and family. The Pulse is brought to you by Global Communities Dignilu, affordable safe sanitation for all, live on DSTV on channel 421 and GoTV 125. Follow us on Facebook, YouTube and myjoyonline.com for these and more. We'll be right back. And we start from the election dispute. The Supreme Court this afternoon had arguments from parties in the disputed Dom Kwabenya and Ablekuma North constituency parliamentary elections. The court is expected to take a decision on the two seats today to bring an end to the disputes that have arisen following the 7 December elections. Having had arguments from the two sides, the court is expected to present its verdict today. We understand that the judges have resumed sitting. Let's go to the court now and take live updates.
Before the court is an application for orders of certiorari and prohibition by the applicants. The first applicant is a political party that sponsored candidates to contest the general elections conducted throughout Ghana on 7th of December 2024. The second, third, fourth, fifth, and sixth and seventh applicants contested as parliamentary candidates on the ticket of the first applicants in the following constituency. That's a matter of record, so you'll get it. At the close of the poll on 7th December, polling station results were declared in all the above constituencies, and the election process advanced to collation of results at the constituency level in order for the winner of the parliamentary election to be determined and declared. In the case of 4 of these constituencies, the applicants contend that the collation exercise had completed and then the parliamentary electoral results were declared in their favor. In the processes before us, the first to 7th interested parties contend that the collation of results was not completed in those constituencies. It was in this state of affairs that the second to 7th interested parties filed series of applications in the High Court and prayed for orders of mandamus against the Electoral Commission, which is the first interested party herein. Their prayers were for the High Court to order the Electoral Commission to undertake collation of in their constituencies and to make a declaration of the winner of the constituency election. In the meantime, the applicants herein had earlier on 16th December 2024 filed an application for judicial review against the Electoral Commission, in their case praying for declarations that there had been earlier declarations in their respective constituencies and praying for injunction to restrain the Electoral Commission from doing another collation. On 20th December 2024, the two applications were listed before the trial High Court judge for hearing. The first application called by the trial judge was that for mandamus by the interested parties herein. the Electoral Commission did not file an affidavit in opposition and stated in court that they were not opposed to the application from Mandamus. However, Mr. Godwin Ebiji Tema of counsel for the applicant's hearing stood up in court and informed the High Court judge that his clients were interested in the Mandamus application and that they had even filed a motion to be allowed to join the Mandamus case. The judge decided to proceed with the determination of the Mandamus application and granted all of them in favor of the applicants therein. It is those rulings dated 20th December 2024 that the applicants have invited this court to quash and to prohibit the trial judge from having anything to do with the applications. The grounds of the applications were as follows. I've listed them in accordance with the motion paper. The interested parties filed affidavits in opposition with exhibits as well as statements of case in which they argued in answer to the case of the applicants. Before the courts could hear the application, counsel for the second to seventh interested party raised a preliminary objection and pointed out that the rules require that at the filing of the application for certiorari, the ruling which is sought to be quashed should be attached, but that was not done. The court indicated that the application should proceed and that in the final ruling would answer the charge. Our conclusion was informed by the fact that there was an explanation in the affidavit as to why the ruling was not attached. And we took note of the fact that now the rulings are before the court, and in order to determine the merits of the applications, which have been well argued by both sides, it was in the interest of justice to proceed. So we proceeded. Counsel for the applicants first stated that since at the hearing on 20th December 2024, the trial judge was notified that the suit to be affected by the proceedings for Mandamus, the judge ought to have joined them to the case in order that they could file affidavit in opposition to the grant of the Mandamus. He further submitted that since their application filed on 16 December 2024 was listed before the judge for hearing the same day, the judge had knowledge of their contention that collation had already been completed and declarations made in 4 of the constituencies. So he ought to have permitted them to put that evidence before him in respect of the Mandamus application. Additionally, the applicant stated that the procedure rules on judicial review in the High Court, which were applicable in the case of the application for Mandamus, being Order 55 of the High Court Civil Procedure Rule CR 47, made ample provisions for interested parties to be added to an application for judicial review, but the trial judge failed to apply these provisions and to add them. Counsel for the applicants relied on a number of decided cases, especially Republic versus High Court Bolgatanga, ex parte Hawa Yakubu, 2001-2002, Supreme Court of Ghana law report. Counsel for the applicants further stated that the trial judge exhibited bias against the applicants by not only failing to admit them into the Mandamus application, but by opting to hear the Mandamus application first when their application for declarations and injunctions was filed earlier in time. In answer, lawyer for the first interested party relied on the statement of case he filed and added that he observed that none of the individual parliamentary contestants had an affidavit before the court in which they complained about any miscarriage of justice. Lawyer for the second interested party, the second to seventh interested parties, stated that he was vehemently opposed to the application. He pointed out that the applicants built their case on the failure of the trial judge to join them to the mandamus application. But he submitted that the rules of the court on non-joinder of a party is to the effect that non-joinder does not vitiate proceedings. He referred the court to the case of Bobier versus 21st Century Company Limited. He submits that the judge had a discretion given to him in the application for judicial review to join interested parties if it was in his opinion. If it was in his opinion that they would be affected by the proceedings. The trial judge did not consider the applicants necessary parties and he exercised his discretion against joining them. He submits that such order would not be granted to quash the exercise of discretion by a trial judge. He referred to the case of Republic versus High Court, the Republic versus Court of Appeal, ex parte Chikata, 2005-2006 Supreme Court of Ghana Law Report. Now, the consideration. In our opinion, the crux of this application is whether, under the circumstances that the trial judge was faced with, could he have proceeded to determine the mandamus applications without hearing the applicants in the form of affidavit evidence and legal submissions on whether the case before him, notwithstanding non-opposition by the Electoral Commission, was a proper case for the grant of an order of mandamus. It is very clear to us that it was plain to the trial judge that the clients of Mr. Godwin Edwige Tema stood to be affected by the proceedings in the mandamus application. And the least he could have done was to grant them a hearing on the facts and the law upon which the application was brought. Our courts, and all courts, especially in the common law tradition, have held this right to a hearing so sacrosanct that under the circumstances of this case, the applicant ought to have been given a hearing, notwithstanding or irrespective of the provisions of Order 4, Rule 5 of CI 47 on joinder generally, and Order 55 on judicial review. In the case of Awuni versus West Africa Exams Council 2003-2004, Supreme Court of Ghana Law Report, the Supreme Court quashed a decision of an administrative body, that is the West Africa Examination Council, for failure to accord persons a right to a hearing. The statute under which the West Africa Examination Council functioned did not expressly confer a right to a hearing, but the Supreme Court held that the West Africa Examination Council ought to have accorded those affected a right, since the right to a hearing had been elevated to a constitutional right in Article 23. If that had been held to bind administrative bodies, how much more a court of law? In the case of ex parte Hawa Yakubu, the High Court in Bolgatanga made orders in an election matter which affected Hawa Yakubu, a candidate at the election. And though she was a non-party, the Supreme Court held that on the facts in the case, the High Court violated her right to be heard and quashed the orders of the High Court. The interested parties say that because Mr. Godwin Edwige Temeklo was allowed by the trial judge to speak, he was accorded a hearing. But they must realize that he was allowed to speak as a friend of the court as recorded by the judge himself and not as counsel for the applicants. This is an unfortunate misunderstanding of what amounts to a hearing in the mandamus application of this nature. Hearing plainly required the applicants to have filed an affidavit in the matter and to have made legal submissions. In this case, none of that happened, so the trial judge violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi-Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash Baseshorai, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okaikwei Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Ahafwano North are not affected by this order, by this our order, and in effect those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our to file affidavits and statement of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed, yeah. Now those which have been quashed, sorry. Those which have been quashed, yes. To file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicants for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for a hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court ex parte Ajua Company Limited, Auditor General Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare, we hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, reliefs A1, A2, A4, and A5 endorsed on the applicant's motion paper are hereby granted, while reliefs A3 and A6 are refused. Reliefs B and C are hereby dismissed. Ordered accordingly.
My lords, we are extremely grateful, extremely grateful. We are grateful to the court. My lords, you are grateful. My lord, there is a second motion on your docket.
Respectfully, my lords, civil motion number JA/30/2025. The Republic versus High Court General Jurisdiction 13, Accra, ex parte the National Democratic Congress. National Democratic Congress. Baba Sadiq, Erabna Uben, Oben, Amenope Philibert Fomi, E.B. Bright, Christopher Bayer, Akwesi Edusei, the Electoral Commission of Ghana, Patrick Yalboama, Nana Ekia Owusu Efriye, Frank Ano Domper, Charles Forson, Martin Kweku Ejay Mesa, Eric Nana Ajiman Efriye, Inspector General of Police. Respectful my lord.
The same parties.
That is so.
My lord, that is so, the same time. And the same representation.
Council, the same representation, Council.
That is what my lords.
Okay.
Let's replace that person with Nana Befi Yabua. Nana Befi Yabua. He will replace Nana Ejay Bafo Ewa. Nana Ejay Bafo Ewa.
Nana
Ejay AJYE. 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 Bafo.
okay, no.
Bafo Ewa.
Yes.
Ewa.
The lawyer,
Yeah, there's a lawyer.
yes, and then now MP.
Yes.
MP elect.
MP elect, yeah. Well, for the 2nd to 7th interested parties.
So, Bafo was replaced by Nana
Befi Yabua. My lord's Befi, BAAFI, and then Yabua.
Okay. Thank you. So, what is the fate of this application?
My lord, in view of the fact that the orders we're seeking to stay have been quashed, we will seek leave of this court to have the application withdrawn.
Yes, Mr. Menugo.
Yes, ma'am.
Any opposition?
No, my lord.
Mr. Nimako.
I lost no objection.
There be no opposition or no objection to the prayer of the council for the applicants. The application for stay of execution is struck out as withdrawn.
Extremely grateful.
first.
No problem.
I think when you finish the whole thing, when you finish the whole matter.
The whole matter.
Yes. Yeah. Yes, Inspector General of Police. I believe you are here. Okay. So you are being moved into all of this. We notice that you didn't file any processes. And it's understandable because your role is very crucial. The role of the police is very crucial. You see what this application has done. During the legal application that we should be, we should resting, we all have to come. We decided that instead of adjourning for a judgment or to give you a ruling without reasons, in order to forestall any unnecessary comments and therefore disruptions, that is why we constrained ourselves and did this. So also play your role as a compared to IGP. You play your role. Neutral persons, and then make sure that we avoid situations which can lead to an escalation of any disruptions. Okay? Okay. Now the political parties. They are not here. There is a lawyers who are. At least there's a general secretary here. It's Okaikwei. Yes. Yes. We also think, as we are talking to the police, make their work easier. You, the political parties, make their work easier. Try and then also help so that we have a peaceful atmosphere as we go forward. Thank you.
All rise.
And so you heard there from the Supreme Court, Justice Gabriel Puaman giving the ruling on the application by the NDC on judicial review of the High Court. And the court has decided that Tema Central, in Okaikwei Central, Tema Central, Ablekuma North, and Techiman South, the re-collation there have been quashed. It does not affect in Sawom, Adwejui, Ahafo Anon North. Those declarations still stand according to the Supreme Court. We also heard that the High Court did not give the NDC parliamentary candidates the rights of hearing. The trial judge also violated the right to a hearing of the NDC parliamentary candidates as well. And the Supreme Court, as a result, has quashed the re-collation in these 4 constituencies. We will be going back and touching base with our correspondent there, Blessed Soga, who's been there since morning when the hearing started. Will be giving us updates, reactions from the NDC and the NPP as well on what is happening over there. We also know that the filing has also been abridged to 2 days. The High Court will be hearing some of the cases again on application on mandamus. We'll still be getting updates there when we touch base with Blessed Soga, who will be giving us reactions from the NDC and the NPP sides as well. Right about now, we'll take a break. We'll return with more. Please stay with us. Welcome back to The Pulse. We go back to the Supreme Court where my colleague Blessed Soga has been doing some interviews and reactions from the NDC. Whether we believe injustice has been done, we fight for them.
All right. Yeah. Any final comments?
No, just to thank the court for a good job and to tell our people to just trust our legal team to do a good job.
Right. All the best, sir. And that's the General Secretary of the National Democratic Congress, Okaikwei, speaking there and giving us a sense of what's likely to happen. You see all of the supporters of the NDC now happy about the decision that was made. On your rear, you see the NPP leadership also filing through. We see the Director of Elections for the NPP now about to address the press. Let's listen to what exactly will be said. But the Director of Elections for the NPP is also here, Mr. Van Sindemako as well. There are a number of issues that concern the Ablekuma North area and other issues that are coming up. We see Gary Nimaku, the counsel for the NPP MP, is also filing in now. So let's listen in and find out from the NPP what their position is. Mr. Nimaku, thank you for talking to us. The court has made its pronouncements. What's your response?
Well, I think that's the decision of the court, and we all abide by it. I mean, essentially, nothing has changed. The bottom line is that they claim they were not heard by the court in the mandamus application. So the court said these 4 constituencies, which have been listed by them, should go back to the High Court, okay, for them to file their response, for the court to make another order for mandamus, for EC to go and collate the results and declare the winner. Nothing has changed. In essence, that's what the court is saying. So really, it's not about jubilation. But then the other constituencies, and then for non-off, there was no collation. So the court said that one should stand. So that one, no collation again, it's going to stand. But the 4 they are listing, that will go back to the court on Tuesday for the court to make another order for collation and declaration. Simplicity.
You have a limited time to work with, knowing that swearing in will be done.
Well, that is correct. That's why we are at a holiday. I'm very, very tired, but we are still coming to work. So it's unfortunate, but to me, it's national service. So we'll go back to the court on Tuesday to get it done.
What is your plan, knowing that the case will be reopened?
There's no plan. We just go back to the court for an order. The same order. We are just simply saying, Electoral Commission, constitutional body, proceed to go and do collation and declaration. That is what we are saying. So we'll go back to the court. They will file their response as the court has ordered. And then the court will hear both sides, make an order, and then we'll make progress.
And give us your position on the CI 127, the part about re-collation not being catered for in the law.
There isn't any re-collation. The collation was not done at all. I've seen Joy News every time you come about re-collation, re-declaration. There is no collation at all. There's no collation. There has to be the collation and declaration. And I made a point. If you thought that you won the elections, why prevent the collation and declaration? If you won the election, why prevent collation and declaration? So I don't get the point. There has to be collation and declaration by the Electoral Commission. So Tuesday we'll go back to the court to go and have it done.
And there are scores of NPP supporters who are watching us now who are not necessarily pleased with the outcome today. What do you have to tell them?
Oh, they should not be worried. You see, nothing really has happened, which to me is bad today. All right? The EC did collation and declaration in the affected areas. And they said they were not heard on the application. They came to court to say that they were not heard. The court said it's a fundamental rule to be heard. So go back to the court and have your matter heard. So it's simplicity. We are going back on Tuesday. They will file their response, okay, on why they think that there was collation or there was no collation. The court will hear the matter, make an order for EC to go and make collation and declaration. That is the point. So there's no, it's not about re-collation. So this word re-collation, there is no collation at all.
Finally, in Sawam Aduejiri and the other one, Ahafo South.
Yeah,
if the Ahafo North, if the NDC decides to contest that again or on a separate platform, what will you do? Because they could injunct
that is up to them. The court has spoken already, so that ends the matter.
You face them?
Face who? We are not fighting. They are brothers. We are not fighting. You saw me hugging them and talking to them. At this year, they are not enemies. We are not fighting. It's a question of the brains. We are not fighting.
The court is concerned about peace after today's ruling. What message do you have on that?
After today's ruling per se, is peace post-elections. You realize that after these elections, there have been a lot of post-election violence. We don't understand. There must be peace in the country. If we won elections, what about the destruction of state properties and all these things? It's not good. So let's all learn to abide by rule of law. That is the way I see it. That is all. So please, all parties, political parties, especially our brothers in the NDC, they should learn to respect the law. That is all.
We're grateful for your time. So that's Gary Nimako, who is the counsel for the NPP MPs or parliamentary candidates who are now being affected by this ruling from the court decision, which was made today by the Supreme Court, caution, the re-collation of some 4 parliamentary seats. That's exclusive, of the 2 outstanding Ahafo South and, of course, the Sawam Aduejiri area, which the court says will stand. We wait to see what will happen on the 31st of December, where the court has directed that the court will reopen its pronouncement on the Mandamos case before the High Court, and then the NDC affected candidates will be allowed to state their case. There's Zogan reporting from the Supreme Court. Back to you in studio.
From my colleague Blessed Soga from the Supreme Court, you heard the reactions from the Gary Nimako, who is the NPP side, counsel for the NPP side. We also heard from the General Secretary of the NDC, Ablekuma. I'm obviously excited about the ruling of the Supreme Court, and that is from the Supreme Court. The update from the Supreme Court, once again, Okaikwei Central, Ablekuma North, Tema Central, and Techiman South results have been set aside, but that does not affect in Sawam Aduejiri and Ahafo North constituencies. On the line with me is our legal affairs correspondent Kwashe, who is also on the line, has also been following the events at court and joins me with updates on what he also thinks about the situation. Kweku, take us through it. You've also been following the events in court. What did you pick up?
So what this means, obviously and technically now, is that the declaration that was earlier on made by the Electoral Commission with respect to Tema Central, Ablekuma North, Techiman South, and Okaikwei Central, which was subject to the Mandamos application, is currently in force. That would mean that when it comes to Tema Central, Ebi Bright has been elected. When it comes to Ablekuma North, Erabna Oben has been elected. When it comes to Techiman South, Christopher Bayere has been elected. And Okaikwei Central, Baba Sadiq has been elected. Their election has not been challenged or anything of the sort. What this means is that the re-collation that was undertaken by the Electoral Commission that led to the declaration of new persons as MPs elect, and which obviously then led to a new gazetting of the results, have all now been set aside. The unanimous ruling of the court, which was presided over by Justice Gabriel Poman, and it's instructive to get to know the panel of this court: Justice Gabriel Poman, Justice Henrietta Mensah Bonsu, Justice Ernest Yaogaiwu, Justice Henry Kofi, and the 5-member panel have come to the conclusion that the High Court, you will recall that the NPP parliamentary candidates in this case did go to the High Court by an order of mandamus to compel the Electoral Commission to recollate the results, because in their view, the recollation had not occurred at all by virtue of what they thought were statutory breaches of the regulation, and some of them done under duress and all that. So they went to the High Court to get the High Court to order the Electoral Commission to recollate those results in those 4 constituencies. The NDC, through Eduji Kujotamaklo, who is the Director of Legal, did apply to join and did go to the court, and we've heard the argument that we made as whether or not the court really did listen to them and actually, as it were, give them the opportunity to be heard. The Supreme Court has come to the conclusion that these persons were actually not given the right of hearing, for which reason that orders that were made have all now been set aside. When it comes to Ahafuano North, and then in Sawamadu Ejiri, and you saw there in your shorts in court, the majority chief whip, Frank Anadompre, who will be smiling because this order does not affect him. The court said this order does not affect them because the court had taken the view that when it comes to those specific constituencies, the collation had not been done at all. And so the Electoral Commission would have been right to start the collation, conclude same, and then declare the results. So when it comes to that results, that is what has been done. But when it comes to those for Tema Central, Ablekuma North, Techiman South, and Okaikwei Central, the Supreme Court has now ruled that the purported re-collation should not have occurred at all in law. It has quashed the order of the High Court that gave the Electoral Commission the legal backing to actually go ahead and do this re-collation. They've quashed it. But the sticking point is that the mandamus application is still before the High Court. You hear the president of the panel say that that matter is still seized with the High Court judge, although the Reverend Father Judge, who presided over the initial case, has been prohibited from going ahead to hear this matter. Another judge will be put in charge of this case. He will then hear the matter, perhaps join the NDC now because the court has said they deserve to be joined to the case. And then when the court hears same and comes to the conclusion that the re-collation must be done, then the re-collation will be done again and whoever wins will be declared. What this ultimately means, and it stems from the legal position of the fruit of the poisonous tree, that whatever was built on the basis of the order of the High Court judge has been set aside. So that re-collation is set aside. Any purported declaration of the persons, the NPP parliamentary candidates for Techiman South, for Ablekuma North, for Tema Central, and Okaikwei Central, who were declared as the winners of that election, have all been set aside, which will mean that the earlier declaration that were made by the Electoral Commission stands, and that Baba Sadiq, Erabin Albin, and the others have been elected. And so next week, when this matter goes back to the High Court, it will be interesting to know if the court will grant the order of mandamus for this re-collation exercise to be done in these 4 constituencies or will not. The time will tell next week when this matter goes before the High Court, Mamisi.
Actually looking forward to that court hearing, which I believe you will be there to cover for us. What do you think will be some of the things we should expect going into this coverage?
Well, yes, I expect I'll be in court. I expect next week for when these matters are recalled. And so we're going to hear an argument again from the Gary Nimakun and the lawyers for the New Patriotic Party, why they believe the earlier declaration was not properly done. They have argued that some of these collation exercises were done under duress, and the Electoral Commission agreed with them, for which reason they actually ordered a re-collation exercise when it comes to this matter. So we're going to hear the same argument they made in court last week. But then when it comes to the NDC, Edwiji Kojo-Tamaklo and the party have made their case that once the declaration had been made and there were video evidence to that effect, the only course of action for the New Patriotic Party and its parliamentary candidates will be to file parliamentary election disputes. And that is parliamentary election petition to go through the rules. And then if the court so finds that the declaration was made in error or in abuse of statute, it will set aside the election or perhaps say that there should be new election or that the New Patriotic Party's candidates should be sworn in. Those are the 2 contending views that we are going to hear in the High Court again next week. And then it will be interesting to know what the High Court will say. And all this is really racing against time because the Parliament of Ghana has started registering new members of Parliament. And on the 7th of January, MPs would have to be sworn in. If this legal dispute perhaps travel beyond then, it could mean that the constituencies in question, these 4 constituencies, may not have elected members of Parliament to be sworn in, or the 4 MPs who were actually declared early on by the Electoral Commission, that is the NDC parliamentary candidates, will be sworn in. But all this have to be done next week because, as we know, on the 7th of January, in fact, on the date of 6th of January, Parliament has put out a program that they will elect a new Speaker of Parliament at 11 p.m. and exactly at midnight they proceed to swear in the new members. So the time will tell, and we will be following this very closely. to bring that to our audience. Let me see.
Well, Kweku, I was actually going to go into Parliament, but since you've taken us there, if it becomes the situation that still these constituencies are in contention and there's no MP to represent them, how then does Parliament proceed?
So the starting point, Mami, is that as we speak, per this Supreme Court's ruling and my understanding of that, the declarations made early on by the returning officers in those constituencies, in Tema Central, Ablekuma North, Techiman South, and Okaikwei Central holds, that would mean the member of Parliament elect for Tema Central is Ebi Bright. The member of Parliament elect for Ablekuma North is Rabna Obin. The member of Parliament elect for Techiman South is Christopher Bayire. And then the member of Parliament elect for Okaikwei Central is Abdullahi Baba Sadiq, the NDC parliamentary candidate. Yeah. They would be expecting that the Electoral Commission would present their duly gazetted results to the Parliament of Ghana for them to be sworn in. If that is not done, and let's say, for instance, next week, when the court hears this mandamus application, the new judge, and is minded to order a re-collation, the results will now be re-collated, and the new person who will be declared in all these 4 constituencies will be given to Parliament for them to be sworn in. If that re-collation is unable to happen for any reason, or if this court case is not heard because of legal gymnastics or any other matter, the expectation will be that on the 7th of January, the members of Parliament elect who were duly declared at the time initially for Tema Central, Ablekuma North, Techiman South, that is the NDC parliamentary candidates, will have to present themselves to Parliament to be sworn in. The legal catch is that these MPs, these persons cannot by themselves present themselves to Parliament to be sworn in. The Electoral Commission will have to duly gazette the results and communicate same to Parliament that these are the persons who are elected for these constituencies, for which reason these are the persons who must be sworn in. It would have been interesting if Blessed can get any of the Electoral Commission officials that this is the status quo that prevails now. Are they going to communicate to Parliament? Because we know that Parliament has so far gazetted 274 constituencies. That includes these 4 constituencies that have not been set aside. What that means is that there's currently before Parliament, there's no member of Parliament elect for Tema Central, Ablekuma North, Techiman South, and Okaikwei Central, until the Electoral Commission writes to Parliament and confirms that because of this new ruling, these are the new persons who have been elected. And all that have to be done. Today is Thursday. Today is Friday, actually. Then yes, Friday. All these have to be done by Monday, when the process is going to continue. Members of Parliament, bar details and other things would have to be captured, their bank accounts to be paid, their ID cards to be issued so that they can enter the chamber. All these must be done before midnight of 6th January or 7th January, or there will be chaos like we saw on the 21st of in 2021. And that is why the ball is now in the court of the Electoral Commission to either write to Parliament and get these NDC parliamentary candidates to be sworn in on the 7th of January.
Kweku, we're grateful for your time on the polls, Parliamentary Affairs correspondent, and also a member of our Legal Affairs desk, telling us more about the events happening in the Supreme Court and also how it's going to turn out in Parliament. Joining us also is lawyer Bobby Bansing, and he's also going to give us more insights into the Supreme Court ruling on the judicial review application by the NDC. We're grateful for your time, Mr. Bansing. What are your reactions to what has just happened in the Supreme Court a while ago?
Good afternoon, Mamiesi, to your listeners. I hope you can hear me.
Loud and clear. Good afternoon.
Okay, I followed the decision, the arguments that were made, and one can only say that, again, the decision of the Supreme Court goes to prove the contention that I've always made, that once you make your submission and submit it with facts and evidence and the law, the Supreme Court, in exercise of this discretion, or whatever court for that matter, may look at your case as it is and grant you the relief that you are seeking. I think that the Supreme Court upheld the application solely on the grounds of the breach of natural justice, even though other grounds were argued by the applicant, and then have ordered that the application for mandamus be heard again for a determination of it on the merits, so that this time the applicants in the Supreme Court would be interested party in the mandamus application, and then the High Court differently constituted, meaning before a different judge, will determine whether or not the EC should go ahead and do the re-collation of those 4 constituencies, the re-collation of which the Supreme Court have quashed.
Declared. Hello, can you hear me, Mr. Banksy?
Yes, Mabesi, I don't know if you heard me, but if you can repeat your question.
Right. Can the persons earlier so declared carry themselves as MPs elect?
Unfortunately, I don't think they can. Once the Supreme Court have said that the basis for which they were declared, which is the second coalition, let me put it that way, or the re-collation, is a nullity, it means that everything subsequent to that is also a nullity. It doesn't mean that they cannot subsequently be declared as MPs elect. What it means is that the Supreme Court said the mandamus application has not been quashed. So that application would again be heard by the High Court, and depending on the decision of this High Court, then the EC may or may not do another collation. And these people, based on the decision of the High Court, may either be declared as now they will not be able to hold themselves out as MPs elect.
Well, what then does it mean for the earlier results declared, you know, the first collation, and what then happens to these results?
Well, the results were based on the pink sheet or the evidence which the EC had. The Supreme Court cannot quash that pink sheet. It means that if they go through the process and the evidence based on which
Mr. Barnes,
it's still there.
I keep losing you. Can you please reposition yourself so that you can go ahead?
Hello, can you hear me?
It's better now, yes.
Okay, so I'm saying that the evidence based on which the Supreme Court, the Electoral Commission declared them as MPs elect have not been quashed by the Supreme Court.
Indeed.
So if those pink sheets are still there and they are untainted, then the EC will only have to go through the process again. So the effect of this does not affect the evidence based on which one can be declared as MP or not. But the Supreme Court has only questioned the processes. That due process was not followed because persons who would have been affected by that decision of the High Court were not given an opportunity to be heard. So the Supreme Court have only said, go back. The High Court should give those persons an opportunity to be heard. If they are heard, and the High Court still goes ahead to make the order for the re-collation, the evidence that is available to the Electoral Commission, which may be the same pink sheet or not, I don't know, then based on that, the Electoral Commission may go through that process again and do a re-collation. That is if the High Court grants the mandamus application. If the High Court does not grant the mandamus application, then what it means is that the collation that were done previously may be upheld. Well, and that will affect the status of those that have been elected based on the second collation.
Right. Can the interested parties apply for a review in this matter?
You mean the respondents, the Electoral Commission and the...
Indeed.
Well, the Supreme Court allows that for every decision that is given, the rules of the Supreme Court, you can apply for a review. But, you know, the ambit for the exercise of that review jurisdiction is very, very limited. And I don't think, listening to the arguments made and the ruling by the Supreme Court, there will be any legal basis for the decision to be reviewed. In any event, we are all interested in going to the merits of the case. And so it is not as if the Supreme Court has shut the door to those MPs. They have only said, go through the processes again, go back to the High Court. And so I believe that it will be in their own interest to go back to the High Court. Because like I said, if indeed the High Court orders the mandamus, the evidence based on which they were declared as parliamentary candidates will still be there, unless that evidence is tainted. And so instead of going through that review process, I believe that it will be in their best interest to go back to the High Court if they strongly believe in the evidence that the EC had at that time they did the second collation or the re-collation.
Well, what do you think about the court's ruling that this quashing order does not affect Insewo Madreji and then Ahafo North? What do you make of that ruling?
I think the decision of the court was based on the fact that I think they said the collation had been done before, or I'm not sure, I didn't get that part of the decision. so I'll not be able to speak to it. As I heard the presiding judge read a paragraph in the applicant's application, affidavit in support, indicating that it seems that those constituencies, the collation had already been done before the order of the court. I am not sure. So that may not be one of the bases, or that may not have been affected by the decision of the High Court. I'm not sure. I would have to check what the basis is.
The re-collation had not been done in those areas before.
Okay. Well, then I would have to check why, because I have not had the opportunity to read the affidavit in support of the application for the certiorari. Yeah, because I heard the presiding judge make reference to a particular paragraph in the affidavit in support of the application for certiorari, and said based on that, their decision would not affect those two constituencies. So I would have to read it and then be informed as to why.
Fair enough. Looking at the legal processes that's going to go into this, do you think there'll be enough time to go through the processes before the MPs are sworn in on January 7?
Well, I believe the High Court judge that will be constituted to hear the case will appreciate the exigencies of the matter. The Supreme Court, in exercise of their jurisdiction, ordered that the application be heard on the 31st, which is the Tuesday. And so if the decision by the High Court judge is delivered on that same 31st, which is doable, or adjourns to the 2nd, I suspect that there will be enough time to finish the process and have whoever is declared an MP based on the decision of the High Court to be sworn in. Unless, of course, the decision of the High Court may also be subject to other appellate procedures or review procedures that may drag the matter beyond the 7th of January.
Indeed. Grateful for your time, Mr. Bobby Benson. He's a private legal practitioner, giving us more insights into the Supreme Court ruling. Well, also joining us on this particular decision is Haruna Mohammed, Deputy General Secretary of the NPP. Mr. Mohammed, what are your views on the ruling by the Supreme Court?
Thank you very much. I first and foremost will say good afternoon to your cherished viewers out there. And I think that we as a country would agree that we have entrusted our hands into a constitutional rule. As a political party, we believe in the rule of law. We do accept the judgment of the court, the decision that's taken by Supreme Court. What they do understand is that the Supreme Court is direct that the case of Mandamus be allowed to be heard for the NDC to be a party to the dispute in their case. So this concerns with all constituencies of which the party, the lawyers for the MP will be represented in court as stated by the Supreme Court. So for us, we are not going to challenge and insult any judge on the panel. We believe that our courts are very competent enough, and we know that we can go to court and have our case being heard. Today, a court has ruled, and the NDC is happy. Tomorrow, when the same court is ruled again, they should be fair to the game and accept the pendulum that today it can be you, tomorrow it can be any other person else. And that is what we do understand. So for Nsawam and the other constituency, I believe that the court was very explicit on this particular constituency. These are constituencies that we all have been saying that it's not all the constituencies that coalition was done. Some of them coalitions were not done. Notwithstanding the decision of the court, I believe that our lawyers will play a very great role in terms of the administrative justice. We will follow through to ensure that when the NDC is heard on the case of the Mandamus, with a change of a judge, we will still prevail in the process. That is what we pray, and that is what we will argue our case in court on Tuesday, the 1st December.
Well, the decisions have been set aside in Okaikwei North, Okaikwei Central, Ablekuma North, Tema Central, and Techiman South, which was previously called for you. I mean, this has been set aside now. How does the party, galvanize in that direction?
Yes, we still believe that the coalition processes as enshrined in CI 127, that is contained in Regulation 43 as in Declaration of Parliamentary Candidates, all the processes were not exhausted. If you read the rules under the regulations, that's Regulation 43, you will see that all polling stations should be guarded, and then all polling stations should be added to ascertain the winner for that particular election. In the case of Okaikwei, you can remember that even when the officer was coerced to declare, he said that out of 140 and 110 to be declared, and he went ahead, even with the threat of if you don't declare, you would not live here in peace, you will kill you and all that. He went ahead and stated clearly, and everybody knows that 30 polling stations were a matter of content which was not added. So the CI says that all polling stations put together constitute the coalition. So once the coalition was not done properly, in line with CI 127 Regulation 43 of the CI, I believe that the court will still prevail and the court will look at the matters and make a determination. So we are not perturbed in this particular process. We have gone through this before. We do understand the remedies that will apply in the court processes, and I think that our lawyers are very sound, and then think that we'll be able to. It is not something that anybody should be either be jubilating or crying over. I want to call on the rank and file of the MPP to be very sure and be very optimistic that the MPP is very sound and very resolute in making sure that the law will prevail, and our members of Parliament will truly be represented by the election and outcome that was so declared. In this matter, too, I don't think that the Supreme Court will also averted their mind to the fact that these declarations is what the Electoral Commission has gazetted. So we live to see what happens at the end of 31st December when these decisions will be reached, and then we would have a complete set of declarations for us to meet. So we are not perturbed, we are not disturbed. Once we sign on to agree the fact that we are in a democracy and we believe in the rule of law, for us, we know that we can pursue this case to its logical conclusion.
Thank you, Haruna Mohammed, Deputy General Secretary of the MPP. Also joining me this afternoon is Rashid Tanko, who is the Deputy Director for Elections of the NDC. Mr. Tanko, Computer, I believe this was the outcome you're looking for from the Supreme Court. What next?
Well, dear, let me say good afternoon to you and your cherished viewers, as well as my brother Haruna. And let me put it on record. All along, I've been telling you people that whatever happened at the High Court was a travesty of justice. Today, democracy has won. We knew that all along what the EC and their collaborators, the MPP, were doing, were trying to subvert the will of the people who voted for certain candidates to represent them in Parliament. And they wanted to steal the mandate of the people. So it's a complete travesty of justice. And so I'm happy with the ruling of the Supreme Court today because the wrong has been corrected. Those constituencies can now be properly represented in Parliament. If you are not satisfied with the ruling, you know the right forum to go. That's why the Supreme Court quashed it. I'm sure my brother didn't follow the proceeding in the Supreme Court. As we speak now, we are left with only 3 constituencies to go back to High Court to argue the case. And those 3 constituencies are the Ansawam Adojiri, Ahafano North, and then Ahafano Southwest. These 3 constituencies is what the High Court has asked that we should go back. And through them, they will file our processes by Monday. Then we argue cases on it as to whether that one they should go back and do the collation process or they should stay that one too. These are the issues we are dealing with. As for the other constituencies, it's gone. They have, so whatever gazette that the Electoral Commission did was illegal, completely illegal. They have to go and revoke it and bring in a fresh gazette to gazette Tema Central, gazette Okaikwei Central, Ablekuma North, and all this in Tema, this in Techiman South. They have to gazette them. These are the constituencies so named in the issues. These were the things they wanted to do, the re-collations and all that. And they have been quashed today.
Well, seeing also that the Supreme Court has also ordered that the High Court judge be replaced, how does that sound to you?
Why would they allow him to continue with that bias that he was showing and sidestepping legal principles? And it was unfair to us, completely unfair. Completely unfair. We're expecting that a high court judge of that nature should understand some of the basic principles underlying natural justice.
I don't have questions.
You are making a decision that will affect somebody. The person wants to join the matter. You say he shouldn't join. You don't see anything reason why the person should join the matter. When they made the decision, didn't it affect our candidate? It affected all the candidates so named in it. So why should he continue to sit on that matter? We are happy they replace him. He shouldn't sit on any issue concerning our matter again because he has shown his biases too much.
Application for a mandamus at the High Court. How then do you proceed on the matter?
Well, we are going to file processes. They've given us 2 days to do that. Our lawyers, as we speak now, are in action. They have gone into action, conclave, to put all the necessary documents together, and we'll file. We are going to fight for that 3 seats. You know, those seats, we are not going to allow it to lie. Mr. Wama Donjiri, they were putting powder on him all over the place. They should go and get another charcoal. They should pound charcoal now and go and put on his head. That was a wrong move. You remember I told you people that the media at that place, when they were doing the illegality, that they were giving them burunya. The burunya has ended today. It hasn't gone anywhere. It won't go anywhere. Because they were trying to steal the mandate of the people. You see, God is so wonderful. And God prevented them from stealing the mandate of the people. You have not been validly elected. You go and get some crooked electoral officers and get some by heart ruling from High Court and to get away with it, to steal seats. That is the only way they wanted to make up numbers in Parliament. Thank God they have been stopped. So we are going to follow them up for the 3 seats again.
Well, on the 2 outstanding constituencies, Dom Kwabinya and Ablekuma North, has there been any word from the EC or IPAC on the issue?
Well, this morning they sent us notice that tomorrow we should come with pink sheets for Ablekuma North and then Dome Kwabinya, 3 pink sheets from Dome Kwabinya, and then that of Ablekuma North. But you see, the Supreme Court has quashed that thing they were going to do. So it's moot now. It's completely, it's a moot issue. They cannot call us for any meeting on that matter. The Supreme Court has stopped them. They were acting on the basis of the High Court ruling. But that High Court ruling doesn't stand as we speak. That has been quashed. So on what basis are they going to call us for pink sheets and others? Our people are validly elected until otherwise determined by maybe a High Court decision after they have been gazetted. They're only duty left for the EC to go and gazette them. Those who are affected can now go to High Court within 21 days after gazette to fight their case there. But not to stop them from being gazetted and sworn in Parliament. That's not their business.
So then, how then do you proceed on that matter? Have you heard anything? Is there going to be a meeting, or there going to be some form of communication between you and the EC on these constituencies?
Well, the EC know what to do. I'm not going to teach them. I'm not their consultant. They know what to do. The right thing is to make sure that those constituencies so named today by the Supreme Court, they go and gazette them. They have no business in interfering in the process. This is to gazette. When they gazette it, then the aggrieved parties who think that the declarations were not made properly can now go to the right forum and seek a release on that place, but not to stop the action. That one is not their business. We are not to show them what to do. The Supreme Court has spoken about it, and then they should know what to do.
Right. Grateful for your time, Mr. Tanko Computer. He's the Deputy Director of Elections for the NDC. And still we have Mr. Haruna Mohammed with us. Your last words, I do want to hear your reaction to also on the matter of changing the High Court judge or replacing the High Court judge in this matter. What do you make of that?
I think it's a decision of the Supreme Court, and we respect that. This is not the first time that a judge has been changed on a case. There are several examples of which judges have been changed on a particular case. You know, the NDC's case in the Supreme Court was on the fact that they were not given hearing rules of natural justice. And my brother is talking plenty on this matter and said maybe I have not heard or listened to the judgment of the court. The court was very straightforward on some of these particular decisions. The decision was that they should be given a hearing, and that was the argument of Edigi So the court has so declared that they should be given a hearing. And the court has directed on 4, and that is why you asked me questions on the 4. And you mentioned Okaikwei Central, Techiman South, Ablekuma North, Tema Central. These, the court has been very, very strict on this particular cases. You see, if he is talking today and he's saying and laughing and clapping for himself, he should remember that if this is how we want to run our elections, in 2028, I can go to a polling station and then put macho men and ask them to declare based on a coalition of only 2 polling stations for my candidate, so that the rest of that will go to court. Then let's prepare for the worst thing in 2028. That is what they are telling us. We are ready and we can do worse things that they think that we cannot do. And this is something we are all trying as much as possible to nip in the bud and to ensure that the right things and the right processes are used. We will go to the court and we will go. They will be given a hearing on the mandamus, and this is going to be on the 4. I repeat, in Sawama Abdulajiri and then Ahabuanono has not been added to the issues of this particular case in terms of these were constituencies that declarations were not made. So there is nothing like re-collation. You know, I have had an argument on the fact that we are not doing any re-collation. The point has always been that collation was not done properly. Collation was not concluded. Collations were not done with the process. So the court gave an order with the application of mandamus for collation to be done. And that was why the collations were completed in those particular processes. If the High Court decides that the NDC were not asked or were not put in as a joiner, the NDC were not given the rules of natural justice, and they are asking that the court be given the opportunity to sit by a different judge for a determination to be made. We believe that such cases are things that we all welcome. We will go to the court and make that particular argument. But let it put it on record. It is not going to be on the whimsical call of the NDC. It's not going to be by the directive of the NDC. We must be very careful to protect this fragile democracy, and that is what all of us are looking at for. We are ready to face any other outcome that they want to project. And I've heard them say that on the 7th, they are going to mass up, they are going to do what, they are going to do whatever in Parliament. If they want to be sworn in, let them be sworn in. If they are going to be chaos, then they are at the side to suffer for it. We are not going to sit down and consent. But what we do know is that we are going to follow through the legal processes and ensure that the right thing is done. Once it is done within the legal processes, we agree to the fact that we move on.
Right. Haruna Mohammed, we're grateful for your time on the polls. And Haruna Mohammed is the Deputy General Secretary of the NPP, giving us their views on the Supreme Court ruling on the application of judicial review by the NDC, which has gone in the NDC's favor. In the constituencies Okaikwei Central, Ablekuma North, Tema Central, and Techiman South, the results have been set aside. And that's it from the Supreme Court. We'll take a break. We'll be back with more. Welcome back to the Pulse. Let's do education now. Major universities have been forced to indefinitely postpone admissions and reopening for level 100 students due to delays in the release of WASSCE results. WAEC, burdened by financial constraints and malfunctioning machines needed to mark objective answer booklets, is struggling to complete the marking process. Despite government recently releasing 25 million cedis of 118 million owed to WAEC, the amount is insufficient to fully resume operations, leaving university schedules in a limbo. In the last few minutes, though, WAEC confirmed receipt of 35 million Ghana cedis. My colleague Michael Ashali joins me with more on this. Michael, what is the latest that you're picking up?
So, Mami, so we've been checking some of the major universities. Let's start with the Kwame Nkrumah University of Science and Technology, KNUST.
Yes.
Looking at the academic calendar for the 2024-2025 academic year, online course registration for freshers, level 100, should start January 2, which is the 2nd of January 2025. And that means that it should have preceded by admissions sometime in December. But that will not be able to happen because This WASI results have not been released. And again, they also expected to do a virtual orientation, but that also will not be done. But there are some groups of people who don't depend on WASI. Yeah. They have been told that they can come to school as early in January. Okay. But clearly, this is early. We've been speaking to the URA, the Investor Relations Officer for the Kwame University of Technology, Dr. Norris Bekwin. We can listen to him make the point about how this is concerning for them.
Right.
Well, all other admissions remain same. The time for reopening remains same, except for the first years who are coming to year one. For those category of students, we don't have results from WAEC, and so we are unable to complete admission processes for those students. Once the results are released, we'll need about 2 weeks to complete the admission process and issues our letters, and then the students can begin to come to school. Well, we are as concerned as any other stakeholder, including all other universities, because we have timelines, we have academic calendar. By this time, we're supposed to have issued our admission letters, but because of the lack of or the WAEC's inability to release the results or process the results early, we have had to have an emergency meeting, management meeting to postpone or reschedule the date for reopening for first-year students.
Well, Michael, you've also been checking with other major universities, especially the University of Ghana. What are you learning? Well,
before I tell you about the University of Ghana, the University of Cape Coast, their process should have started as early as the 23rd of November 2024.
Oh, that's way back.
Yes, a month ago. That would have started with the fresh level 100 students reporting to school, and then the orientation would have continued on the 25th of November. But we know that will not be able to happen. Yes, those are one of the universities that are struggling to keep up with their timetable. And then at University of Professional Studies, we also know that as early as December 16, the registration for level 100 should have started. Right. But here we are, December 27, that cannot happen. At the University of Ghana, what we know is that registration for freshers should have started by December 30th, which is about in 3 days' time. Right. But possibly that will not happen. That again should have also preceded by admissions, but that hasn't happened as it stands. I'm also speaking to the Pro-Vice Chancellor of the University of Ghana, Professor Gordon Awandari. He tells us that it's concerning. There's no way to work around it, but they are waiting for the results, and as soon as they come, they'll be able to release admissions. We can listen to him.
Very concerned, because already the academic calendar has been disrupted so many times. So we are really, really worried about it, and you know, we hope that there will be a resolution. In fact, the fact that the WAEC exams are now being taken, you know, later than normal, that's already impacting the university calendar. So we're hoping that next year they will go back to May, June exams so that we can do the admissions around September, October, so they come to school with the rest of the continuing students. So this is making things worse, actually. So we hope there will be a quick resolution. We'll need about 2 weeks to complete admissions. I mean, within 1 week, some can be done, but for us to cover all the disciplines, to take about 2 weeks.
Well, Michael, seeing what is happening in the public universities, I'm so sure the private may also be facing this challenge. What are you learning of anything of the sort?
So, Mamiesi, most of the universities actually, their major source of students are those who are just coming from the senior high schools who have to write the WASI exam. Yes, so if the public universities haven't gotten, then clearly they also can't get their fair share of these pool of students that have to decide to join them or not. Hopefully, when